In the previous section, we examined the detailed steps and statutory requirements involved in a deed of trust foreclosure, emphasizing the trustee's sale as Arizona's most common non-judicial foreclosure process. Now, we focus on what actions can stop or delay a trustee's sale once it has been scheduled. While the trustee's sale process is designed to be efficient, Arizona law provides several remedies and opportunities for homeowners, lenders, and courts to intervene before the sale occurs. Understanding these options is vital for both homeowners and real estate professionals assisting distressed property clients. Once a notice of trustee's sale has been recorded and the 91-day period begins, the borrower, truster, retains certain rights up until the day before the sale. The most common and straightforward way to stop a trustee's sale is through loan reinstatement. Under ARS, paragraph 33A3A, the borrower has the right to reinstate the loan by paying all amounts currently in arrears, including missed payments, late fees, trustee's fees, and foreclosure costs, before 5 p.m. on the last business day before the sale. Upon full payment, the trustee must cancel the sale and record a notice of reinstatement, restoring the borrower's rights under the deed of trust. For instance, if a borrower in Gilbert misses 3 months of mortgage payments but pays the full delinquent amount the day before the sale, the foreclosure is halted and the loan is reinstated as though no default occurred. A second method to stop a trustee's sale is loan payoff. If the borrower pays the full loan balance, including principal, interest, and all accrued charges, prior to the auction, the debt is satisfied, and the foreclosure process must cease. This often occurs when borrowers sell the property before the trustee's sale and use the sale proceeds to pay off the debt. Escrow officers handling short sales or traditional sales must carefully verify loan payoff amounts and ensure the trustee is notified in writing of payment to cancel the sale. Another action that can halt a trustee's sale is filing for bankruptcy protection. Under federal law, 11 U.S.C. Part 362, the filing of a bankruptcy petition triggers an automatic stay, which immediately stops all collection and foreclosure activities, including trustees' sales. Once bankruptcy is filed, the trustee cannot proceed with the sale until the court either dismisses the bankruptcy or grants relief from the state of the lender. For example, if a homeowner in Scottsdale files for Chapter 13 bankruptcy 2 days before a scheduled trustee's sale, the sale must be postponed. The automatic stay provides temporary relief, allowing the debtor time to propose a repayment plan or negotiate with creditors. However, if the bankruptcy is dismissed or the lender successfully petitions the court, the sale can be rescheduled. In addition to reinstatement, payoff, and bankruptcy, court injunctions or lawsuits can also prevent a trustee's sale from proceeding. A borrower may seek a temporary restraining order, TRO, or injunction from the Superior Court if they believe the trustee or lender violated statutory requirements, such as failure to provide proper notice, misapplication of payments, or errors in the amount owed. In Madison v. Groseth, the borrower challenged a trustee's sale on the grounds that the trustee failed to strictly comply with the statutory notice requirements under Arizona's Deed of Trust Act, including proper mailing and service of the notice of trustee's sale. The Arizona Court of Appeals reaffirmed that trustees must strictly follow the notice provisions set forth in ARS, per favor 33-808 and 33-809. However, the court ultimately held that because the borrower did not seek injunctive relief before the sale occurred, the borrower's claims were barred under ARS paragraph 33-811C. The case is frequently cited to illustrate both 1. The importance of proper statutory notice by trustees, and 2. The rule that a borrower must seek a TRO or injunction before the sale to preserve objections based on notice defects. If a trustee failed to mail notice to a junior lien holder or published it incorrectly, a court could issue an injunction delaying or canceling the sale until the error is corrected. Another, though less common, method of stopping a trustee's sale is mutual agreement between the borrower and lender. The lender may voluntarily postpone or cancel the sale if the borrower demonstrates intent and ability to bring the loan current, or if negotiations for a loan modification, short sale, or deed in lieu of foreclosure are in progress. The trustee must record a new notice if the sale is postponed beyond 90 days, ensuring public transparency. In practice, these actions often overlap. A borrower may file for bankruptcy to delay the sale while simultaneously negotiating with the lender for a modification. It is important for real estate professionals to understand that while they can explain these general options, they must not advise clients to pursue any legal action. Under Commissioner's Rule R428-1101B, licensees must act within the scope of their expertise and refer clients to qualified attorneys for legal assistance regarding foreclosure defense, bankruptcy filings, or injunctions. For example, an agent working with a distressed seller in Mesa might explain that the seller could stop the trustee's sale by catching up on missed payments, paying off the loan, or seeking legal help if the lender failed to follow procedure. However, the agent must not draft legal filings or suggest specific strategies beyond general education. Discussion. What is the most common way for a borrower to stop a trustee's sale before it occurs? Answer. By reinstating the loan, paying all past due amounts, late fees, and foreclosure costs before the sale date. What is the effect of filing for bankruptcy on a scheduled trustee's sale? Answer. It triggers an automatic stay under federal law, which immediately halts all foreclosure proceedings until the court allows them to continue. Under what circumstances can a court issue an injunction to stop a trustee's sale? Answer. If the borrower can show that the trustee or lender failed to comply with statutory requirements or acted improperly during the foreclosure process. Review summary. Stopping a trustee's sale in Arizona can occur through several actions, including reinstating the loan, paying off the balance, filing for bankruptcy, obtaining a court injunction, or reaching an agreement with the lender. The borrower's reinstatement right exists up to 1 business day before the sale, while bankruptcy and court orders can pause or cancel proceedings entirely. Lenders may also voluntarily postpone sales during loan modifications or short sale negotiations. Real estate licensees must understand these remedies but avoid offering legal advice, ensuring clients are referred to attorneys for professional guidance. Awareness of these processes allows agents to provide informed, compliant assistance to homeowners navigating foreclosure.